Hi guys, welcome back to my channel. Welcome if you're new. I hope you're having a wonderful day. My name is Kseniya and I make videos for people who, like myself, are going through the family-based immigration process. I'm not an immigration attorney and my videos are based on publicly available information, my own experience, and the experience of my subscribers. The purpose of my channel is to give you guys the confidence to go through this process completely on your own. Last week, I published a step-by-step guide on how to complete the form I-134A. So in today's video, I wanted to answer some additional questions that I have received. And hopefully after watching this video and the video guide that I posted last time, you will feel comfortable submitting this form. The first very commonly asked questions that I have received is how many forms I-134A to fill out if you are trying to bring multiple people from the countries that are available to participate in this program. Based on what is written on USCIS site, you have to fill out separate forms for each person you plan to support, even underage children, so even children under the age of 18. If you are submitting the form I-134A for a minor child, I wanted to pay your attention to the section called Beneficiaries Financial Information, and in this particular section, you will fill out information about the beneficiary's income and beneficiary's dependents. Thinking about this logically, you most likely will only have to input the name of the minor child in here. So here you will just have to indicate then the total number of dependents being 0, and then how much will the beneficiary's dependents contribute will probably be 0 as well. And assets, here you won't be providing any of the information because if it is a minor child, most likely they will not have any income at all. So that is that as far as the first question is concerned. But yes, according to what it says on USCIS site, you do have to fill out a separate form I-134A for each person whom you're trying to help. The next question that I frequently get, and that is how to enlist a co-sponsor. In this particular case, when it comes to the form I-134A, the procedure is slightly different. Again, all of this information is available on USCIS site. I will link these pages under this video so you can go and read it for yourself. However, this is what it says. At least one form I-134A must be filled out for each beneficiary. Multiple supporters may join together to support beneficiary. In this case, a supporter should file a form I-134A and include in the filing supplementary evidence demonstrating the identity of and resources to be provided by the additional supporters, and attach a statement explaining the intent to share responsibility to support the beneficiary. These supporters' ability to support a beneficiary will be assessed collectively. So in this particular case, only the primary supporter will fill out the form I-134A. However, if there is anybody else who would like to contribute their income, they will not be filling out an additional form I-134A. They will simply be included in the application. So based on what I'm seeing, you will most likely just have to include it in the evidence portion. So most likely in this particular portion that says proof of assets of individual agreeing to support the beneficiary, perhaps here, if you would like, you could probably also add the information about any additional sponsors in the additional information section. And here perhaps you can add a short statement about any additional persons that would like to join their incomes. And obviously when it comes to uploading all the necessary evidence, you would just have to, aside from just the primary sponsors, financial information, wherever applicable, whether it is tax returns, whether it is an employer statement, whether it is proof of assets, here you will probably will have to upload the information from both the primary supporter and also anybody else who is agreeing to support. In addition, you need to keep in mind that the form I-134A requires an individual to sign the form. Organizations may not serve as the named supporter on the form I-134A. However, if an organization or other entity is providing financial or other services to the beneficiary for the purpose of facilitating support, this information should be provided as part of the evidence submitted with the form I-134A and will be taken into account in determining the supporter's ability to support the beneficiary. So basically, all of this is saying is that an organization or a group may not be a supporter. This means that there needs to be a specific person associated with the form I-134A. However, if there is an additional organization or group or some kind of community center that is willing to add resources or add financial resources or any other resources to the beneficiaries, they may be included in the part of the application that asks about any additional organizations or groups that are involved in the process. If, again, like we said earlier, you're planning to have an additional person help you support the people coming, their name should not be listed here in group, organization, or entity name because that doesn't apply. However, if there is some kind of church or community organization or some kind of community center or any other entities that are willing to support, then you can list them here. And again, anything that you list must be backed up by evidence as well. In that case, you would want to include evidence that states what kind of organization it is and what kind of resources they're going to make available to the beneficiary. Okay, the next common question that I get is, can you file the form I-134A for family members of the beneficiary who are not citizens of the listed countries? So can you file for somebody who is not a citizen of Cuba, Haiti, Nicaragua, Venezuela, or Ukraine? Again, based on the information provided on the USCIS site, it may be possible if the persons are immediate family members of the beneficiary that you are supporting. So the immediate family members in this case are spouses or unmarried children under the age of 21. Okay, the next question is, can you apply for I-134A for somebody who is already in the United States? The answer is no. However, if you are a person from one of these countries and you are currently located in the United States, you can apply for TPS, the temporary protected status. And the TPS is something that you have to continuously apply for, I believe, every year or every few years, as long as those countries are designated as being under temporary protected status. Okay, the next question is, can the beneficiary apply for public benefits? Meaning, can a person who has been paroled into the U.S. on this I-134A program, can they apply for public benefits? The answer is yes, technically they can. However, the application process for various public benefits is somewhat complex. And so the sponsor of the beneficiary, so the person, the supporter, must support the beneficiary in the application for these benefits. However, in many cases, if you seek public assistance from the government, you will be asked to provide documentation of supports already available to you. So having a supporter in the United States who signed a form I-134A on your behalf may make it potentially difficult to apply for these benefits or to become eligible for these benefits. However, it's always worth a try. Your supporter in the United States should technically be helping you in applying for all of these things, because that is what they sign up for by signing the form I-134A. The next question that I got was, if the sponsor, the supporter, is obligated to pay for the beneficiary's food, travel and stay, medical expenses, etc. So USCIS site states that the sponsor or the supporter should be able and willing to do the following: receiving the beneficiary upon arrival in the United States and transporting them to initial housing, ensuring that the beneficiary has safe and appropriate housing for the duration of their parole and initial basic necessities, as appropriate, helping the beneficiary complete necessary paperwork such as employment authorization, social security card, and for services for which they may be eligible, ensuring that the beneficiary's healthcare and medical needs are met for the duration of parole, and as appropriate, assisting the beneficiary with accessing education, learning English, securing employment, and enrolling children in school. So basically, what I am getting from this information is that the supporter who signs the form I-134A should be helping the beneficiary in applying for all of these things and completing and helping them in any situation that they need. However, it doesn't specifically state that they are by law obliged to do so. But you should be aware that by signing a form like I-134A, it is, after all, an application. It is a legal document that you sign with the government. And so you definitely should be following through of any obligations that you have promised on those applications. And if you can't, then you probably shouldn't be a supporter in this case. The next question I have is, can you apply for I-134A for your family member and then petition for them using the form I-130? So yes, that is allowed. What you need to remember is that the wait times and the eligibility requirements are different for various family members. And so if, for example, you are a U.S. citizen supporter and you helped your mom or your dad, maybe your child, come to the United States on this humanitarian reasons, and then you began the I-130 process for them, and then you also submitted the adjustment of status application. Now, because they are immediate relatives of U.S. citizens, you are kind of able to, for the most part, combine the petition and the green card application process for them. However, if you are a supporter helping out your maybe an older child who is married or who is over the age of 21, or maybe you're trying to help your brother or sister come to the United States, you need to keep in mind that the petition I-130 for family-based green cards is the only step you would be able to take at that moment. And when it comes to applying for an actual green card for these people, you definitely should be looking into the form instructions, following the visa bulletin to see when approximately your relatives will be eligible to apply for a green card. Visa overstay is not forgiven for relatives other than immediate relatives of U.S. citizens. So you want to really keep in mind in terms of how your beneficiary is going to maintain a lawful status in the United States for such a long time while waiting for their spot in line. So those are some of the things you need to consider. The other question that I get is, if you are a supporter who is a friend, what relationship should you put on the form I-134A? If you look in the form itself, here it asks to provide the individual's relationship to the beneficiary. And there are many options that you can pick. However, some people were wondering, if you are just a friend, what would you put? So you have two options. If you are a somewhat related family member, you could say other family member. And then if you are a friend, the only other option available is not specified. So you may potentially want to put that. And again, you are welcome to include any evidence that you believe will be helpful. If you have any evidence supporting your relationship, even if you are just friends, you may want to include that. I mean, that is something that I would personally do. Again, this is not any kind of legal advice, but just thinking about it logically, maybe that's something you would want to include. Maybe some kind of letter or statement based on the information provided by USCIS is you do not have to be related to the beneficiary in order to be a supporter. If you are looking to be a supporter for one of these programs, but you don't actually know any particular beneficiaries that you would like to bring to the US, there are two websites that USCIS links in their on their site that will help you become a supporter and will connect you to a family or an individual who is in need of such a humanitarian parole. So I will also link those two websites under my video, but one of them is called welcome.us, and then the other one is called Sponsor Circle Program as well. The final question that I frequently received is, can you apply for a green card after being paroled into the United States? Unfortunately, there's no direct pathway for you to become a permanent resident once you've been paroled in the US. Again, like we mentioned earlier, if you have a family member who can petition for you, that is something you can do. Employment is another path that is suggested by USCIS, and also parolees. So if you've been paroled and you are approaching the 2-year expiration mark, you may also apply for temporary protected status as long as your country is still actively designated as TPS by the Department of Homeland Security. Asylum is another option that some parolees may choose to take. However, when it comes to an asylum application, you must prove to the Department of Homeland Security that you personally will be persecuted if you return back to your home country. And when it comes to asylum applications, you definitely should be discussing this with an experienced asylum attorney. So these are some of the most common questions that I have received in regards to this form. I hope that you found this video useful. I hope I was able to answer most of the questions for you. I know that a lot of people are wondering about current processing times. Unfortunately, I do not have that information, but if you would like to share your personal experience, please comment it under this video or under the other video that I have posted in regards to I-134A. Please subscribe to my channel if you haven't already. Give this video a thumbs up so more people can see it, so we can help more people. And I hope to see you guys in my next video. Bye!